let's talk about Murthy. What is the Murthy case about?
The Murthy case is another Fifth Circuit case. It haunts my dreams, Sam. I'm telling you, this damn court.
Well, my last thing I have on my list to talk to you about is the changes in venue shopping. But let's talk about this, because in the Texas instance, I mean, it makes sense that it's in the Fifth Circuit, maybe like we'll talk about that. But let's talk Murthy first.
Yeah. So here, two Republican AGs in Missouri and Louisiana filed a lawsuit in a single judge division in Louisiana District Court, knowing that they would draw a Trump judge named Terry Doughty, who is a notorious anti-vaxxer. He wrote this truly insane opinion a couple of years back saying that COVID vaccines don't work. He's notorious for issuing these sweeping nationwide injunctions. So these two Republicans go into his court and they say, we want you to issue a nationwide injunction that prohibits the entire federal government from communicating with any social media company in a manner designed to even mildly encourage them to remove or moderate any content involving COVID. Now, the backstory here is that people may remember in 2021, 2022, the Biden administration was working with Facebook, Twitter, a couple other platforms to try to tamp down the rampant anti-vax misinformation at the time, stuff about taking ivermectin to treat COVID, this idea that vaccines caused cancer, and all of this dangerous stuff. The White House and some other agencies were working with like Facebook to say, hey, this information is wrong. You should downgrade it or you should remove it. And we encourage you to actually put out the facts that COVID vaccines work and ivermectin doesn't. It was not coercive. It was not like do this or else. These were task forces that were set up at the request of these platforms to work in partnership. That was the term the platforms used to try to ensure that they weren't making the pandemic worse. So these Republican politicians decide that that is a violation of the First Amendment. They go to Terry Doughty, the Trump judge. Terry Doughty issues what may be the most sweeping nationwide injunction in the history of the country on July 4th, 2023, a nice little patriotic flourish, 150-page opinion. And he says the entire federal government, the entire FBI, from like the director down to a desk secretary, the entire Department of Homeland Security, the White House, like all of the government, every employee is now personally gagged from ever talking to any social media company about any controversial issue, not just coercing them to do one thing or another, but just communicating with them, because they are engaged in a relentless and coordinated campaign to shut down the free speech of COVID vaccine skeptics. The Fifth Circuit naturally upholds much of that injunction. That is the setup for Murthy, which the Supreme Court heard on Monday. I think it's safe to say the Supreme Court is not pleased that it has to deal with this garbage pail of a case. The less insane conservative justices like Barrett and Kavanaugh seemed confused how things could go so badly awry in the lower courts. I think the top line thing here is just that it doesn't violate the First Amendment for the government to tell private companies what it thinks. That is a pretty bedrock rule, that the First Amendment only kicks in when the government's engaging in censorship. There was no government censorship here, so there's simply no First Amendment problem at all.
I mean, there's a couple of thoughts I have on both sides of it. One is like, what would be the line is one question. And two, in the event that they found Murthy in favor of this being censorious, or like an abridgment of the First Amendment, like how could the government sort of like meet with business leaders and say, hey, we think you should start paying your workers more? Like, I mean, I wish they would, well, let's put that aside and but we hear about this all the time. I mean, there was business leaders that went into the White House all through COVID where it was like, you need to start producing more of this stuff and you need to do that. Now, obviously, we're not passing a law that does, and we're not going to put you in jail. But this is what we're asking you. How could the government do that if they're not allowed to say to a social media platform, you should police the false information that's coming out?
So the plaintiffs in this case, the anti-vaxxers, the Republicans, would say, well, what's different here is that the government is trying to censor the speech of third parties. So it's not just that the government is pressuring a social media platform or any other private company. It's that this is a company devoted to hosting other people's speech. And so when the government steps in and says, hey, this says that you should put ivermectin in your eyeballs and it'll cure COVID, you should probably take it down, that is silencing the free speech of whatever poor unfortunate soul put ivermectin in their eyeballs and posted about it on Twitter. I think the response to that is, and this is actually something Justice Brett Kavanaugh brought up, which is kind of funny, but he was White House staff secretary. One of the jobs of White House staff secretary is to call up newspapers and yell at them for publishing stuff. Say, this imperils the troops, this is wrong, this is too mean to the president, whatever. He actually said on the bench, I give him credit for it, he was like, look, this is what government officials do all the time. They call up the media. They say, I don't like this op-ed. I don't like this piece. You shouldn't print that. You shouldn't print this. No one has ever thought until this case that that is a First Amendment violation. But the attorney, the Louisiana Solicitor General arguing for the kooks in this case, said, well, that has always been unconstitutional and we just didn't realize it, that it took this case for everyone to understand it. And he said that even mild encouragement, so not just like not coercive. We're not even talking about coercion. We're not even talking about like enthusiastic encouragement. We're saying calling up a company and saying you should maybe consider taking down this post or not publishing this op-ed, that alone violates the First Amendment and that courts have to step in and gag any government official who would dare to do such a thing.
We should also say that obviously corporations do this all the time.
Yep.
That is, there are people who are constantly hectoring any type of outlet, regardless of whether it's Twitter or what, as to their corporate agenda. Now, of course, they don't have the power of the government, so it's not like a First Amendment issue, but this dynamic exists. So where would the line be crossed?
So this is something that the Deputy Solicitor General talked about a lot, and I think defended a clear, bright line here. So I think if you call up, if you're whatever, White House staff secretary, Surgeon General, you call up Facebook, you say, you should consider taking down this post about COVID vaccines causing cancer because it's wrong. That is fine. That seems to clearly fall on the line of not a constitutional issue. But if you add to the end of that, and by the way, our antitrust division is seriously looking at breaking up Facebook for monopoly violations. And if you don't take down this post, then we might have to look into you a little more carefully to see whether we need to bust you up. That would cross the line into coercion. So there has to be a real threat of some kind of enforcement, some kind of punishment against the platform before it crosses the line. And that follows from this decision from the early 60s that the court kept talking about called Bantam Books, where basically the state of Rhode Island created this commission that was going around to bookstores telling them, nice little bookstore you got there. Wouldn't it be a shame if it got shut down because it printed stuff we don't like? That's coercion. I think we all agree, that is a violation of the First Amendment. But nothing of the sort happened in this case. It didn't even get close to that line. And so, again, it's sort of a mystery to me how this case reached the Supreme Court.
The only thing that is reminiscent of is when I think Donald Trump was saying that about Bezos in the Washington Post. And he was saying, nice company, Amazon, but we should maybe look into that for antitrust or something like that. I mean, he literally did that. I think it was, but apparently.
It doesn't count when Donald Trump does it.
That's my understanding. All right. Lastly, this change there's a federal judicial rulemaking body, which I was not aware of apparently, that has changed the process in which you could venue shop, like what it sounds like the Murthy people did in this instance. Explain that to us and just how big of a deal this is.
So in a couple red states, Louisiana, Texas primarily, they have these outpost courthouses in sort of random places like Amarillo, Texas, Monroe, Louisiana. They're called single judge divisions, which means there's just one judge who sits in that courthouse. Now, if you only watch TV about the law, that might not sound surprising, but actually federal district courts have many, many judges on them. And traditionally, when you file a case in a federal district court, it goes into the spinner that used to be an actual physical machine. Now it's an electronic thing. and is randomly assigned to one of those judges to prevent the plaintiff from picking their judge, because it is obviously deeply unseemly and looks very political for a plaintiff to be able to handpick which judge is going to hear their case. The single judge divisions have developed as a workaround to that, a kind of loophole, because these judges are the only guys in their courthouses, and these district courts under conservative judicial control have essentially suspended the rule of random assignment and allowed these judges to take and hear and decide any case that somebody files before them. So the Murthy case is one example. Probably the most notorious is the medication abortion case, the mifepristone case last year, right? That was filed in Amarillo, Texas, not because it had any true connection to Amarillo, but because the Trump judge who sat in that court, Matthew Kacsmaryk, was guaranteed to hear the case and guaranteed to rule against abortion because he's a lifelong abortion foe. The Judicial Conference, which is, as you said, kind of obscure, but an important body that sets the rules, has now come out with a rule saying that has to stop, saying random assignment is the rule. There should not be exceptions. And that is especially true when the policy or request or lawsuit or whatever involves some kind of nationwide relief, like a nationwide injunction, like an injunction against the entire federal government or something like that. That if it's a major case that involves major policy disputes, it has to be randomly assigned. Now, the kind of stinger here is that no one is entirely sure how the Judicial Conference can enforce this rule. This is not a body that has traditionally exercised a lot of direct hard power. It's usually more of a soft power kind of thing. And so if these judges in Texas and Louisiana refuse to play ball, I do not know what will happen. The Chief Justice is the head of this conference and the head of the judiciary. Presumably he can try to kind of like wield some hard power to rein in these rogue judges, but it is going to be a battle within the Article 3 judiciary. And at this stage, I cannot quite say who will win.
Interesting. And so what is the proposal as to how you avoid, like, just if you're a single court justice, you're just not eligible to hear this stuff? It's got to go to a bigger, like how in practice, never mind, will they enforce it? How do they articulate the rule?
So the rule is you might file in Amarillo, but the headquarters of that district court are in Dallas. And so your filing is going to go into the same spinner that every other case goes into and is going to get randomly assigned to some judge who sits somewhere within that geographical district.
Okay.
Might still be Amarillo, but will probably be Dallas. And that way, there's at least a fighting chance that a more impartial judge will hear the case. Matthew Kacsmaryk and Terry Dowdy and all of these goons aren't going to be able to just lay claim to these sort of partisan cases and use them to seize a whole lot of power from the Democratic branches.
Really interesting and very helpful. Mark Joseph Stern, senior writer at Slate, as always. Thanks so much for your time today. Really appreciate it.
Thanks so much. Always a pleasure.